And then
Yeah, sure.
we have to say yes. At least we did last, remember?
It doesn't ask.
Cameron,
Yeah,
did it ask you if it's okay to record? You know,
yes,
it asked you?
yes, it accomplished, all right. Like a half a second after you said, let's do it and push the button.
Okay, we didn't get our message.
We got a.
Oh, that's special.
I did on the computer.
On the computer, okay, good.
I think we're recording.
Okay, yes, Cameron says we're recording and
That's not the first page.
we're all, how did you get us to the record on over?
It explains that just being recorded, and you get a guide. The blue button says God, so it's being recorded.
Did you do something to record that?
Well, I did it on big screen.
Okay.
Books.
Who's that one?
Very small person.
Farther away than you were looking.
What do you think? It's not moving again. This way. That sound was
Oh my God. Yeah, well, then you can do this.
Is that right, Alan?
Yeah. The bench, things back and forth.
Yeah, I think you're right there. So it does.
Well,
Can you give it a chance?
I was telling that. So I, you know this book. Maybe so she never did so. About years of. And she brought it back. It's called. Oh, yeah. How you doing? Yeah. 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 But it didn't feel. Absolutely. I see. Does it work? Okay.
maybe that's just trying to do it.
What else do we have to do today?
A little hard.
Yeah, I know, right?
Oh, they.
Documents.
Well, I don't understand.
Okay, everybody, I think our time is with us, so we'll get started. Just in terms of where we are and where we're going, we are going to today talk about the administrative law cases. There have been 2 of them so far. There's going to be another one next term because the court just this last week granted cert in another case of the administrative law type. And we'll talk a little bit about that one. That'll be coming next term. But there's going to be an overhaul here, complete overhaul of administrative law in the process of these 3 cases. So we're going to talk about that first, and then we're going to move into the abortion case. Today is the 1-year anniversary of the overruling of Roe versus Wade in the Dodd case. And so the fact that it's been a year helps a bit in understanding where this is likely to go, because there have been developments in the course of that year, including lots of lawsuits and legislative action in a number of the states, and we'll go through and do an overview of that and talk about where that's likely to go, and we'll also talk about some of the issues that are out there that are going to have to be confronted. And unlike CNN, CNN has been pushing experts all week to make predictions about what's going to happen in Ukraine and what's going to happen in Russia and what's going to happen here and here and here. Well, I'm going to try to resist that as much as possible. There are a few areas where I can make a safe prediction, I think, but there are quite a few where I can't, which means this is going to be a dance fest to take the theme of today's service for the legal profession, in the course of the ensuing years until all of us get straightened out. So, okay, administrative law. I want to talk a little bit about what that is, and how important it is. As we mentioned before, you won't find any mention in the US Constitution because there were no administrative agencies at that time. And there was no body of law called administrative law, just simply didn't exist in 1789. And at most times since, it arose really in the late 19th century and then came to its own in the early 20th century because somebody decided, and then this happened in a whole bunch of contexts, that law in certain areas was just so complicated that it needed constant regulatory supervision. And it wasn't something that the legislature wanted to spend all of its time taking up year after year to change it, to add to it, to modify it. So the legislature began the process, and this happened here in California, it happened in the federal system, it happened lots of other places, setting up administrative agencies to do this. Well, first of all, our primary sources of law, where we look when we say this is the law, when some commentator on CNN says this is the law, what do they mean? Well, typically they mean there's either a provision of the Constitution, United States Constitution or California Constitution, if we're here in California, or a statute passed by Congress, California legislature, and then also precedent cases interpreting both constitutions and statutes, telling us what they mean, and then applying them in some context that then serves as precedent future cases. That's typically what we have. There is nothing in traditional primary law about regulations or agencies, but now, after more than a century of experience, we have administrative regulations that we have to add to that mix because they are a form of statutory law where the agency makes a rule and that rule has to be followed. So, it's part of the body of law. And as I think I mentioned when we first discussed this, strangely, you would think administrative agency law would be at the bottom of the scale here in terms of lawmaking. But under the supremacy clause of the US Constitution, an administrative agency of the federal government can make a rule that supersedes everything we do in California, including our state constitutions. And that becomes supreme. You would think a constitution has got to be, federal is the key. Everything that's federal supersedes everything that's state. If the federal government acts either through congressional legislation or through a valid regulation of a federal administrative agency. Well, now where did we get all the power to do this? This is an expansion of the Commerce Clause in the United States Constitution, and I've got the clause here. The Congress shall have the power. Notice it says the Congress, because this is something the Supreme Court's going to remind us of when we get these new cases, and when we talk about the cases that we already have. The Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So if there was commerce, trade in that context in 1789, of course, this was a lot of physical trade. Didn't involve, much computer purchase. Didn't have Amazon stopping at your door at that point. But all of that is within this commerce power, and therefore Congress shall have the power to regulate that. Well, but then, if Congress has that power, what about all these agencies? I mean, because Congress isn't doing all of this. The FCC is doing it. The FDA is doing it. All of these different agencies. Well, continue the rest of this clause. So Congress has the power to regulate commerce and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. This is a broad grant of power. And it says Congress not only can regulate commerce directly, it can do that indirectly by creating and delegating the power to an administrative agency. And the administrative agency then makes rules which also become part of the congressional power. And this is something that's important to keep in mind, because in this sense, administrative law is subordinate because it's got to conform to the statutes, the legislation that Congress passes. If an administrative regulation violates something that Congress does, it's invalid. It's going to be bounced.
So you're saying that a congressionally empowered agency, a congressionally empowered agency can supersede a state law unless it conflicts with federal law?
Right.
Ouch.
But that is the way it works. But again, it's subject to the law that creates it. In this case, Congress. If Congress passes a statute, and typically the way this is reflected, if you want to look for it, you take a look at the particular statute that creates an administrative agency. Whether that's the EPA or any particular agency, you look at the statute, and the statute will say we'll have a specific provision for rulemaking, and it will say we the Congress hereby empower the EPA to make rules, and those rules, again, consistent with our statutory power. Those rules are subject to that, and it's implicit there, and you got hundreds of cases that have done it. It's invalid if it violates the statute. So that's an important aspect of this power. It's broad power, but it is subject to a limit. So Congress delegates lawmaking power as necessary and proper, creates agencies, empowers them to adopt and enforce regulations, and this is what we do because it is designed to further the public interest. I mean, normally you have a statute, and okay, some people get mad because their rights have been violated under the statute, what do? They bring a lawsuit. They sue whoever violated it, including, a federal agency and they take this to court. Well, but wait a minute. Isn't there a broader public interest in many of these areas that are being regulated in food and drugs? Isn't there a broader public interest there? Well, the answer is yes. Isn't there a broader interest in commerce? Controlling commerce. Do we have situations? And this is what I constantly think about this, and I'm sure the rest of you do too. As you look at things that happen to you in the marketplace when you're participating in it, and you just wonder, well, now, wait a minute. Well, how come they can get away with doing this? Because I really don't have a choice here. Some of these things where supposedly we've got competition. How much real competition do we have in some areas? Take, for example, cable TV. I mean, it isn't like there isn't competition. Yeah, there's some. There are three biggies that are there, but it's difficult to switch back and forth. You certainly don't want to sit there and say, well, I'm mad at Comcast this month, so I'm going to change my whole service to something else because of the investment of time, the hassle, the expense of making that change. All of those are barriers to competition in the marketplace, which means competition is not a perfect solution to many of these things. It's not like you get a great smorgasbord from which you pick. That's the theory, Adam Smith theory of competition. It's the invisible hand. The marketplace is out there, and you make a whole bunch of choices, and then it all comes out wonderfully. It's just great. It's fabulous. Well, sometimes it is, and sometimes it's not. And in these instances, if you have monopoly power, or if you have even what we call oligopoly power, where there's a few people that control, or a few businesses that control the marketplace, the public interest is not there. And so we move in with regulation to superintend the marketplace. And the agencies are all the ones that I've studied and I've worked with. And I've worked with, done work in the context of the FCC. I've done work in the context of FDA. And there's an emphasis there that if the market is really working, the agency's going to let it work. Even though they might have power to regulate it, they're going to let it work. But if the market is not working, they're going to jump in, and you're going to see pages and pages of regulations to specify how things are working. One of the areas that I'm sure we've all wondered about, how about airline service? You're laughing, I laugh too, I mean, and believe it or not, guys, we used to have pretty effective regulation that then got dismantled by statutes that said, oh, we don't have a problem. Look, we got all these airlines. Well, yeah, but in a lot of routes and a lot of instances, you don't have more than one airline going there these days, especially in light of COVID and all this kind of stuff. So you gotta have somebody providing some oversight. Sometimes, I just wonder how you fit into the space thing if you're on an airplane. I mean, it's really, this is the kind of thing that demands a public interest regulation. And so we all talk about the public interest. I remember I had a professor in law school, and his name was Glenn Robinson. And I took administrative law from Glenn Robinson at the University of Minnesota Law School. And the last day of class for administrative law, Glenn Robinson came into class, walked up to the front and said, ladies and gentlemen, I have been appointed to the Federal Communications Commission. So I am going to be departing and going to Washington. And of course, we had heard, a lot of his thinking about that agency and what it should do and how it should regulate communications. Glenn would just be really pushed out of shape when he sees what's going on in communications. since the time he sat on the agency. We all kind of followed his career on the agency because he did a lot of dissenting. He disagreed a good bit with what the commission was doing, or should I say, not doing, to protect the public interest. But this is a very elaborate process that we go through for this. So what are some of the origins of this? I'm just giving you 3 examples here. Interstate Commerce Commission. This is one of the early ones, because it started at the federal level regulating railroads. And we had, of course, at the state level, we had problems with railroads. The reason that we have initiatives in our California Constitution, and we constantly have these ballot propositions that we have to deal with, is because in the early part of the 20th century in California, there was such a fear of the domination of railroads particularly, and then also other corporations, other forms of large business, that people threw up their hands and said, we can't trust the legislature to handle this, to regulate in this area. So we, the people, have got to have the right to come in here and place something in the Constitution if we see something that's awry, amiss, not looking after the public interest.
Tony, just
yeah.
as an aside, in the state of Texas, where I just spent 37 years, the Railroad Commission is the most powerful commission in the state. And it's because the oil industry has fallen underneath the Railroad Commission. Because, of course, it was the railroads at the start.
Right.
Okay, but as the oil industry developed, it became big, it was funneled under the Railroad Commission. So here you have the Railroad Commission handling the oil industry.
Well, and those of you who know anything about the history of railroads know where that power comes from. And it comes essentially from the rights of way that the railroads acquired or were given. The idea behind all of this, when we set up railroads, is and the railroads were of course the driving force here. They said, look, we got to have all this land. We've got to be able to fix trains and fix tracks and fix, we got to, come on. So give us 2 miles on either side. Oh my gosh. And they did it. They did it. And so they wound up with that kind of grant of property. And so then what they did is, once things got moving and they had their whole rail system built, they started selling it off. They didn't use it, they sold it off. And guess what happens? When you sell off property in a high demand market, they got filthy rich. And that was at the beginning of the 20th century. So, okay. Commerce, yes.
Maybe you're getting to this as part of bullet 3, but what's the relationship between commissions and agencies?
Okay, good question. The words themselves don't pay attention to it. You could have a commission that is operating as an administrative agency. I use the term administrative agency because that's the term we use as administrative law, but quite often they have the title commission. So you have to look at the particular agency or commission and what their powers are, and then you can figure out whether that's the case. I'm trying to think, almost every commission, Federal Communications Commission, yeah, that's an administrative agency.
The people that are on a commission are federal employees?
They are federal appointees.
Appointees.
They get appointed by the president.
Yeah, so that's the difference.
Yeah, it's an executive agency, so they get appointed by the president.
Yeah.
And they do run things, they make regulations, they create the regulatory atmosphere. So second thing, state workers' compensation commissions. Oh, that was the first introduction I had when I walked into law school. And I went, the first class I was taught by Dean Carl Auerbach. And Dean Auerbach was a traditional law teacher, we don't have any teaching like that anymore. It would be regarded today by students as abuse. And at that time, it was regarded as good legal education. This is what we need to be doing, because Auerbach would come in there and he had a massive seating chart. He would call on people. And, and then, if you weren't prepared, oh my gosh, then he would, jump around, call on other people. And if you said something, he would look at Beth right now, makes a contribution, she says something. Carl would stare at Beth while she's making this contribution. And at the end, if he didn't like what she said, he would just go on and say, all right, lost. So they're totally devastated by the way she's been treated. But this was the way they treated everybody. And Carl, and by the way, Carl remained a friend of mine until the day he passed away, because I love respect in terms of what he was teaching us. Because he was teaching us how to argue by, this kind of rough way of doing this stuff. And he eventually had a high compliment for people. He would say, he'd stare at you and then you'd say something and he'd say, yes. And that was a high compliment. But the highest compliment he ever paid, and I got a couple of these in the course of this class we took. Yes. Did you all hear that? So you live for those. And it's like you live to get that from him. Because Auerbach was smart. Oh my gosh, the guy was terrifically smart. But one of the things he wrote about, and our textbook was written by him, and so we got to read about this, was the workers' compensation system. How did we get to the workers' compensation system? Well, the answer to that question is it went through a series of stages where workers, particularly through the Industrial Revolution, in the late 19th century, were getting hurt. These machines were hurting people. And what did we have to deal with that? Well, first, we had nothing at that time. We had a common law, and so you started out as a worker, you had to sue. And you could try to sue your employer, or you could sue a co-employee and then try to argue that the employer was responsible for the co-employee. And oh my God, there was tons of law being generated in that, not terribly favorable to workers. And so finally, somebody threw up their hands, and Auerbach traced this in the state of Wisconsin, which was our neighboring state to Minnesota. But it started workers' compensation. And so finally, the legislature of Wisconsin said, no, we can't, this is ridiculous. We've got to give people some compensation. So workers' compensation, if any of you know anything about it, it is a system that is a no-fault system. You get injured at work, you're covered by workers' compensation, and you have certain things that you can get there. You don't get a chance to bring a lawsuit. In fact, you're forbidden to bring a lawsuit, but you do get paid a compensation for disability. You also get all your medical expenses paid, and there's certain other kinds of payments that are made through that system. So again, that was something that replaced common law lawsuits. Now, the last remark here, administrative agencies are rule makers, but they don't just make rules. They are prosecutors and judges concerning the conduct of regulated actors. So we would not tolerate this anywhere else in the legal system. But literally, an administrative agency has a bunch of employees that are empowered to enforce the regulation they pass by prosecuting people. In some cases, bringing them into proceedings in the agency itself, in other cases, bringing them into court. But they are going about enforcing this, and they also have other members of the agency, which act as judges. They hear the case. Now, they do maintain some independence between the ones that are prosecuting and the ones that are hearing the cases. They aren't all going out to lunch together. They are part of a separate part of this, but they are a self-contained body. Now, I should add very quickly, at the end of this process, there is the prospect of going to court. You can take an agency decision, in other words, and get it reviewed in court. So that's your ultimate safeguard if you think the agency's done something bad to you.
Right, no question, but is the IRS an administrative agency?
Oh, yes. Oh, yes.
I
Yes.
understand.
And there are proceedings that take place within the IRS. They have their own tribunals to hear things, but then they also have the United States Court of Claims, the United States Tax Court, and the federal courts are also available to you once you go through the agency. If you're dissatisfied with what they've done with your taxes, you can take it further.
Good, thanks.
That's what happens here. So, okay. So now, contrast the use of litigation and regulatory mechanisms in rulemaking. I take the example of consumer products, because this is what I have been most familiar with and have worked with. So products, cars, automobiles. And I put an example I actually worked on, baby walkers. You guys remember baby walkers?
Yeah.
And then now, the most recent one, hard plastic sharp edges on rubber ducky.
Right.
These things now have apparently some manufacturer of this product for little kids puts a hard plastic edge, and these kids are getting poked and injured by these edges, cut, that kind of stuff. And then I also had a case once of retail racks. I'll see if we want to get to that in a second. But
Retail rats?
retail racks, in a store, where you have merchandise around a rack. Have you noticed, folks? We don't have those anymore. There's a reason for that. They were dangerous.
Little kids love to hide in them.
Little kids love to hide in them. Little kids also like to pull on them. And guess what? They come tumbling down and the little kid gets hurt. We had some cases of serious injury to that. I worked with another lawyer that was doing this kind of stuff. So the problem with products initially, and frankly, you still have it. We don't really have effective regulation for products. What we have is the litigation system. Prevention of injury here is difficult or impossible in litigation. In other words, if I'm litigating against some company, it's very difficult for me to get from the court an order that fixes the problem, or the order that's needed in several of these cases I'm going to mention bans the product. You can't get that from one court. The court won't give it to you. All the court thinks they're there to do is give you money. Now they do have some broader power, but money is what lawsuits are about. They drive it. So the question is, how do you try to affect the system, change the rule, ban the product in a lawsuit? It's very difficult, particularly given what I call settlement bribery. And I have observed that take place. I've observed a company that does not want to change what they're doing, literally bribe the lawyer that comes in with a case. And when I use the word bribe, I mean they pay way in excess of the value of the case just to shut that lawyer up and never hear from them again and get them out of there. That's the kind of stuff that does indeed go on. And so, for example, I work with another lawyer. I do typically legal side of these things, so it wasn't my case. but the lawyer had a baby walker case where a baby had been put in this device. You know, they move it around in this thing. Kids got a kick out of those. They allowed the kids to, even if they weren't ready to
Move around.
to move yet, you know, they can move on their own. They could move in this thing. Because it was just, they could just do enough with their legs and it would go someplace, and they loved it. Yeah, but very dangerous product. In the case that I worked on, the baby took a tumble down some stairs and was killed.
Oh.
And so, you know, what do we do? What do we do? There was an agency called the Consumer Product Safety Commission. And they did have the power to block these things, but they weren't doing it. They weren't doing anything like it.
Did they hold the parent responsible, but maybe the parent should have?
Well, you know, they would listen to all kinds of excuses, but essentially they wouldn't do anything. At the end of the day, they wouldn't do anything. And so, and we, you know, the lawyer I worked with was a very responsible lawyer, and he wanted to see this product banned. And so he did file something that I did the work on primarily in the Consumer Product Safety Commission. And they sat on it for 3 months or 4 months and dismissed it. You know, and in the meantime, he takes this case and he has them pay him, oh, I don't know, I think it was $1.5 million or something like that, for the death of the baby. And of course, the death of the baby is incalculable to the parents, and that kind of thing. But that was an overvaluation of what the, you know, the litigation value of that case would have been if it had been tried. But they just wanted to get rid of it and get rid of it in such a way that, you know, they wouldn't see this come again. You know, so again, they use that device because then they can keep doing it. And finally, the Consumer Product Safety Commission, in a subsequent petition, there was so much political pressure brought on them that they finally cracked. And they did ban baby walkers. And so you won't see baby walkers anymore. And that got done, but not without a great deal of agony. And it wasn't done in any direct or straightforward way. Now, the rubber ducks, they're still out there, as far as I know. Yeah.
I just wanted to ask about the gag rules that I've read about where there's,
Yeah.
where they come to a fruition or of the cases, you know, pled and agreed to, and then there's a gag rule.
Yeah.
How does that work and how do we? get
Well,
around
and I
that?
mean, the gag rules are essentially there because if you have private parties and you're not talking about the government, there's no such thing as a gag rule if the government is involved. Then it's open. And they can't have gag rules on the settlements and things they do. But if it's private parties, that is deemed to be a matter of contract. You enter into a settlement agreement, you have a contract, the contract contains a provision insisted on by, in this case, the defendant, the party that gets sued. No, nobody can mention this, and nobody can mention it, nobody can mention anything about it, nobody can disclose the numbers, nobody can disclose anything about this. That's perfectly legal and perfectly valid. It is the kind of thing that many of us think. No, there's if there's any conceivable public interest, sometimes it truly is, you know, just something between two parties. It doesn't have any broader implications in public interest, but in the case of products, for example, quite often it does have that.
I'm thinking of PG&E and how corporations are now people.
Yeah. Okay, that's an amazing thing in and of itself, you know. You look at the Constitution and it says, uses the word person. And somehow, in the late 19th century, corporations got to be persons. Well, how in the screw did that happen? I mean, because for example, you look at what was occurring at that time. you had corporations and all of a sudden they're involved in lawsuits. Well, okay, what is a corporation? And how did they get started? Well, the corporations are creatures of the state. And I do mean literally the state here in California. We allow people to incorporate. And it used to be at the beginning of this, they would get a charter from the legislature, giving them permission to incorporate and to operate as a corporation. Well, later on, the legislature got sick of doing the paperwork. And so it became the kind of thing where we have a Secretary of State in California now. And you go to the Secretary of State and you file a set of articles of incorporation and you pay a fee, of course. And they would then say, aha, you are now a corporation. Great, I'm a corporation. But I'm not only a corporation, it didn't look like, anybody was born there, but you're a person. You just became a person. And you walk around with the rights of a person in terms of your ability to go into court and get things, or to protect yourself in court. And that's truly something, and I have no explanation for that other than, that the US Supreme Court in particular as an institution has been very protective of corporations in its history. And I would say now probably maybe even more. Legislation can anticipate and address all problems. Regulation, however, can be more specific. It can be based on expertise and study by that agency of a particular area of endeavor, like products, for example, or like railroads, or like, any other particular foods and drugs, any other particular area. And so these are the kinds of things that can happen. And quite often, if we don't have effective regulation, and I would contend we don't have it in consumer products, we just don't do enough there to have enough rules or anything like that. Most consumer products, there are no rules at all. So you have to sue. And I remember once I got a magazine from a lawyer organization I'm a part of, it had a picture of a car in the magazine, and then it had arrows pointing to particular things on the car. And then behind each arrow, there was a citation to a particular lawsuit that was brought because that piece was defective. And that lawsuit established either a safety mechanism or made some rule that caused the automaker then to change that piece in the next iteration. So the car literally was the product of design by litigation.
How many arrows roughly? 10, 12?
Oh, no. We have about 20. This is, it's ongoing, and it goes on with, and we have gotten better cars because of this. But look at the expense, look at the length of time it takes to get that done.
Well, and also I've heard that we have fewer lawsuits in personal injury and products liability because things are safer. People are now anticipating, the lawyers are gonna come after us, we better do this, we better do that, we better do that. The lawsuits have gone down because all those crazy lawsuits.
And part of it was the bugaboo that we have all been taught to hate, which is called punitive damages. Because quite often in those lawsuits, if a product manufacturer intentionally perceived a risk, saw that the risk was out there, and they don't care. They're gonna put that out there anyway, and they know people are gonna get hurt. The Pinto was the class. Anybody remember the Ford Pinto?
Yes.
Well, the Ford Pinto was a situation where somebody sat down and did, wasn't back of the envelope either. They did a memo, a nice memo that talked about, if we don't redesign this thing, and we see that this thing is you're gonna hit it, and it's gonna explode, you're gonna have all kinds of problems with this because of the engine being in the rear and, all this kind of stuff. What if we do nothing? What's it gonna cost us? And so literally, they calculated, the cost of a wrongful death suit. This is what we're gonna pay on the average to send this person on to their maker. All this kind of stuff was on a piece of paper. And they concluded at the end of the day that, yeah, okay, we could fix this. And there were various ways we could fix it, no question.
But
we
it
could
was
fix
hard.
it. But we're not gonna do it. We're just not, we're gonna wait, yeah.
Is that change of the corporations to a person like is that the beginning of all of our Citizens United and our beginnings of lobbyists and all of that?
Actually, that's a separate track.
Okay.
What that problem is, what is free speech? Okay, I'm speaking now. I'm speaking to you. That's speech. That's speech. And that's subject to rights and limitations. Now. Keep it in the family here, it's community property anyway. Was that speech?
No.
Yes, it is. In God bless America, that is speech.
Money talks.
I don't get it, but that's, and the US Supreme Court has a series of cases. You can keep it. I've actually got a couple of 20s in there, but I never own them.
Took us one the other day.
But this is the kind of thing we build on that. There are 3 cases in that line leading to Citizens United. Citizens United was not something, lawyers didn't expect. We look at it now, and of course, it looks like it's a watershed. But the reality is they were leading up to that with striking down particular kinds of campaign and contribution regulations. Because I express myself when I put down $500,000, $1 million. That's fair change, right? To somebody that wants to influence the process, and the process is worth to them in government, maybe worth millions and millions and millions. Yeah,
I think
So-
that didn't jump on you, by the way. I think you jumped a slide.
Okay. Let's see. Oh, wait a minute. Yeah, right. Okay, now. Okay, all right, yeah. I don't know how I jumped a little bit. Let me just get my bearings here again. Yeah, there it is. Now, okay. So we have these agencies out there. They operate, they regulate, they do all kinds of things, and we're going to be talking about these in connection with abortion too, because we're going to have some agency issues there. So let's talk about the cases. So we have 3 of them that we're going to discuss. Let me make sure I've got that right. So actually, I'm gonna back this up in just a second. All right, here's the case. Here's the case that the Supreme Court has just granted this week, a petition for certiorari to be heard next term. Here's the issue. Should Chevron USA Inc. versus Natural Resources Defense Council Inc. be overruled? Question mark. And at least 4 justices voted to hear that. They want to get a chance to consider and possibly do that. Well, let's figure out why they would want to do that. Now, they did the same thing, by the way, in Roe versus Wade, same question. So, okay, Chevron USA. This is what we call the little Chevron 2-step, which is what Chevron's holding was. This was the closest I could get, Pastor Derek, to get dancing into, this is the Chevron 2-step that we're going to look at. So, this is what the court says. First, always is the question whether Congress has directly spoken to the precise question at issue. So this is a case where we were looking at a regulation of an agency If the intent of Congress is clear, that is the end of the matter, for the court as well as the agency must give effect to the unambiguously expressed intent of Congress. Okay, all right, that's saying just what I said earlier, that is that Congress controls here. If this violates the statute, violates what it is Congress did in the statute, it's invalid. We throw the rule out. Don't enforce the rule. If, however, the court determines that Congress has not directly addressed the precise question, the court does not simply impose its own construction of the statute. So in other words, if you're looking at a statute and there's no direct violation, but there's a question of is whatever happening in this regulation may be inconsistent in some way, or it will undermine in some way what's in the statute, then the court doesn't in that situation just say, okay, all right, then I'm going to make up my mind what the statute means. And then if I think it means something other than what's in this regulation, I'm going to throw the regulation out. No. You have to respect the expertise of the agency. Congress put this agency there to regulate in this area, which means over time, the agency, its staff, all of the work that it does become experts in the area. And so if they interpret their job under the statute in a particular way, the court should go along with that. If the statute is silent or ambiguous with respect to the specific issue, the question for the court is whether the agency's answer is based on a permissible construction of the statute. So in other words, we defer. It's called deference, where we defer to what the agency says the statute means, and don't just say, oh, no. I'm the court. I know what the statute means, so I'm going to determine that independently. No, it's not independent. They're experts. You're not. You're sitting as a judge. You're not an expert in foods and drugs. So you're going to. Pardon?
Unless you're in Texas.
Unless you're in Texas. But so okay. So there is a rule of deference. This is the two-step. This is how you step around. You know, the idea of maybe there's a violation here, but we're not going to determine it independently. We're just going to defer. We're going to say, no, it's kind of a mess here. So we'll defer to the agency. You know, we won't take responsibility ourselves to determine what this is. So, okay. The EPA here adopted something called a total plant emissions interpretation of the relevant act here, which was the Clean Air Act. Okay, this is clean air we're dealing with. You notice who the plaintiff is in this case? Oh, whoops, wrong one.
Chevron.
Yeah. This is Chevron. Yeah, the plaintiff here is Chevron USA Inc. versus the Natural Resources Defense Council. So it's Chevron that is suing this group and is asking for a determination, and they're being told they're arguing that this regulation's invalid, and they're being told by the court, no. We're going to defer here to what it is the agency does. They had a total plant emissions standard rather than an emission per device interpretation. So in other words, they look at a plant, electricity plant we're talking about. They look at the plant as a unit, and they say, okay, how much pollution is coming out of this plant? That's what we're going to regulate. That's what we're going to set the standards. We don't look at all the different sources of pollution in the plant and set limits on those sources. This is just that our approach to this is to look at the plant. And this is what, no, this is going to be reconsidered next term. Justice Gorsuch has already expressed in his lower court opinions his disagreement with the whole idea of Chevron. As will the Chevron two-step become the Gorsuch stump? In other words, are we going to deal with a situation from now on where the court arrogates to itself the power of determining what the statute means without looking at what the expert agency says about it and its experience and what it has to say in areas that are highly technical?
and require some kind of expert analysis. So this is what I call a Gorsuch stomp. You're gonna stomp on this. And that, the question itself tells you what it is they intend to do. And so don't be surprised when you see this one as the next one. Now, here's another example of that. SELA versus the the Consumer Financial Protection Bureau. This is an agency that had a lot of powers to fines. It was created and passed through Congress when the Democrats had a majority in both houses. It basically allowed a single director who was the head of this agency, not a board, but a single director, to exercise all kinds of powers. And that was an example of one that was struck down. Agency violated separation of powers by intruding on executive powers, in other words, by placing this immense amount of power in the hands of a single director. Now, air pollution. Notice who the plaintiff is in this case.
West Virginia.
All right, so guess what this case is about? We don't have. It's about coal.
Yeah.
Guess what it's about. Qualify that word coal the way they would qualify it if they were arguing here.
Work.
Clean coal. Clean coal. Clean coal. One of the things my father did for a living at one stage of his career, and he used to take me along when he did this sometimes, is he would take loads of coal and put this in, and this was bituminous coal. You have anthracite, bituminous, lignite. So bituminous was in the middle of this, but it meant that it burned dirty.
Yeah.
This was not clean coal. And he would pick this up in a device, a machine that he operated, and move it over by crane and dump it into a chute where it would be burned to produce steam to make electricity. This was an electrical power plant. So, but again, this is now. So the EPA has something called a clean power plant rule. That should be, and that is plan rule, by the way. It's not plant. They called it that. Section 111 of the Clean Air Act allows the EPA to determine emissions limits with which states must comply and which they must enforce. And so the agency derived this limit by setting the best system of emission reduction that has been adequately demonstrated, or the BSER, for the kind of existing source at issue. So they look at a source and they ask, what's the best way to reduce emissions? And that's what they would do. And the statute specifically authorized them to do that. And the limit would then reflect the amount of pollution reduction achievable through the application of the system that the agency had set to determine, what the emissions ought to be. Okay, well, that seems straightforward enough. Before 2015, the agency set emissions limits based on the applications of measures that would reduce pollution by causing the regulated source to operate more cleanly. In other words, they would literally say, okay, what is this plant going to burn? It's going to burn coal. This is clearly, my father was doing this stuff way before 2015. And so it's going to burn coal. So are they using the cleanest available technology to burn coal? If they are, it's great. It complies. They don't have to do any more. Ladies and gentlemen, please. I mean, there isn't anything you can do to make this any cleaner. I mean, you can pretend you're doing it. You can put certain kinds of emission devices that will get all sooty, and then you throw them out and they absorb some small amount of it. But they would say that was the best they could do, and so that was good enough. Well, by 2015, the EPA woke up. And so, it had never considered before that time, for 2015, the prospect that, gee, maybe there isn't clean coal. Maybe there isn't a way to make this any cleaner so that we can actually reduce these emissions.
Right.
So we have to go about this another way. And the other way was shifting polluting activity from dirtier to cleaner sources. But ladies and gentlemen, this is what West Virginia we're talking about in the States. We are discriminating. I mean, we're discriminating in favor of natural gas, for example, which is, by the way, a much cleaner source than bituminous coal would be. So they revised the rules.
Take away.
And they forced a shift here, and the way they did it, they said, we're gonna try to take the overall mix of electricity generation from 38% to 27%, so knock off about 11%, and we're gonna do that by 2030. And this was done now in 2015. So, you know, we're allowing 15 years to make a transition into reducing how much we're doing with coal, to still doing 27% in 2030.
So that's less than 1% a year.
Yeah, less than 1% a year. You would think that all of this has got the hallmark of reasonableness, given the fact that clean coal really doesn't work. You know, you're shifting away from coal, but you're doing it in a very phased kind of way. You know, I mean, that would be my argument if I were trying to argue for the reasonableness of this. But guess what? So the court says precedent teaches that there are extraordinary cases in which the history and breadth of the authority that the agency has asserted and the economic and political significance of that assertion provide a reason to hesitate before concluding that Congress meant to confirm such authority. Oh, come on.
Really?
Congress didn't mean to confer authority here. I mean, they're giving you the whole responsibility for emissions. You have to determine the best system of emission reduction. And you have to demonstrate that for the kind of existing source at issue. For goodness sake, what do you want for a grant of power? It's very broadly worded, very broadly worded. And it was intentionally broadly worded by Congress. So okay. So the court says, we hesitate because of the immense economic and political significance. Well, it isn't like they didn't think of the economic and political significance. They got a 1% a year reduction here going on. And so, I mean, again, all of this was self-evident, but the court is saying, no. This is the major questions doctrine. And we're gonna, if it's a major question, we're gonna say Congress couldn't really have intended that. They really couldn't. I don't think they did. I mean, come on, so they didn't intend what they said. This is what they said. So, okay. The government can offer EPA's authority to establish emission caps at a level reflecting the application of the best system of emission reduction adequately demonstrated. That's the language of the statute that I just read. The word system, however, is an empty vessel, they said. Such a vague statutory grant is not close to the sort of clear authorization required. Well, come on.
Who wrote this?
Who wrote this? I've forgotten now. I think at this time it was a Scalia or one of those guys. But I mean, the government points to other provisions of the Clean Air Act, specifically acid rain and national ambient air quality standards that use the word system or similar words to describe sector-wide mechanisms for reducing pollution. So it's clear the statute meant this to be a broad word. You envision a system and then you try to create and improve the way that system attacks the problem. I mean, so this isn't hard to figure out, and they do it all the way through the statute. But that's dismissed here by the justice as, well, that's just a cap and trade system. And just because that can be used to reduce emissions does not mean that it is the kind of system reduction referred to in section 111. Oh, God, okay.
I'm not
Okay, it's
persuaded.
just, I mean, this is more wishful thinking than it is reasoning. Finally, the court has no occasion to decide whether the statutory phrase system of emission reduction refers exclusively to measures that improve the pollution performance of individual sources, such that all other actions are ineligible or qualify. It is pertinent to the court's analysis that the EPA has acted consistent with such a limitation for 4 decades. What they're saying is, hey, for 4 decades, guys, for 4 years, you've regulated this way. You have not looked overall, in other words, at what contribution a particular source is making to emissions. You have envisioned this in a completely different way, and so you cannot change your mind. And this is one thing I truly marvel at this, because it's like saying, okay, this is the scope of your authority. You are the agency, and this is the authority. You have to regulate here systems that produce emissions. Okay, that's your authority. There isn't anything in the statute that says exactly how you have to do that, but you better do that in some way that you are reducing these things. Okay, and then you look at it and you decide, well, I'm gonna try out something that's not gonna be the total authority that I have. I'm gonna do a smaller amount of that. I'm gonna try to use source emissions, by plant or in some very specific ways, where I don't look at the fact that it's coal. I simply look at whether is this the best. Let's call it the best source, and actually the best source by plant and by the particular source. Okay, that's a part of there's a piece of my power. That's a piece of the power that I have, and I'm exercising that, and I do it for 4 years. Maybe I just scratch my head and say, that didn't work. We're not getting these emissions down. Yeah.
So I'm curious, the Clean Air Act, as I recall, was adopted in like 1990.
Yeah, something like that.
With a focus on sort of acid rain was one of the focus.
That was one of the things that.
And so at that time, there was no really climate change sort of greenhouse gas in the air.
No.
And so what I'm curious about.
Well, excuse me, the Congress held a hearing in 1980 on climate change, and a whole bunch of scientists presented all sorts of evidence. This is 1980.
And they passed the Resources Conservation Act in 1985.
Well, again, I mean, I think both of these things are true.
Can I ask my question?
Yeah. No, but I don't think that was specifically envisioned by Congress. They knew about it. Yeah, they've been told about it, but they were aimed at dealing with other things when they wrote the statute. That's all I'm saying. Yeah.
So my question is, and again, I don't agree, but I'm trying to get inside the head of the originalist thinking.
Yes.
And I'm curious if part of the thinking is that the Clean Air Act really was not targeted at climate change related issues. Therefore, this is, regulating in a way that's not consistent with the original intent of the law. So I'm just curious if the justices are kind of leaning on that type of thinking when they make these rulings.
Yes, without question, they would perceive what they're doing as perfectly consistent with the way they interpret the Constitution, which is to use its original intent. And here, they're dealing with a little bit different thing here, because if you have a congressional statute,
right,
this is the act of Congress that we're talking about. You have 2 houses in Congress. So they generate all kinds of stuff when it goes through.
So a reasonable rebuttal to that would be the 2 points that were made in the audience here, which is it was clearly known at the time that, you know, climate change was in the air and they gave broad discretion over this.
Right, and they chose extremely broad language.
Yeah.
They did not put in all of these different problems as the limitation of the power that they were doing. They didn't say acid rain. They didn't say that, you know, that kind of stuff. They put in much broader language. Because what if you're sitting there in Congress and you just say, okay, we got a problem with what's getting dumped in our air. And we know some sources of that problem. But we can't envision all of them. And we want this agency to be able to be the expert here and to keep track of this. And if necessary, to go ahead in its judgment and regulate other sources that are going on. And we can't guess at what all of those might be. One of them might well, 1980, we had the hearing, one of them might well be climate change. You know, that could be one thing. There could be other things. We don't know. So we have broad language because we don't know, and it's not something we want to keep revisiting. If it were, we wouldn't have an agency at all. Or we would have an agency with extremely limited power. So we would have to keep coming back and dealing with every more source.
Yeah, the one other follow-up question I had, I'm just curious if you'll get to it, which is the recent wetlands decision.
Yeah.
Yes.
All right, I want to, I'll hold that question.
So somehow I had the second case. Somehow this thing is skipping around on me today. Okay, all right, now that's okay. So there's one case. And that's what the first case that the Supreme Court used to say, all right, we're gonna start limiting this power. We're gonna start limiting this power, and they're signaling that they're gonna do it by taking the power back from the agency. All of a sudden, the agency can interpret the statute the way they would like to have it interpreted and have the court defer to that. The court will just make up its own mind, independent.
No more experts, in other words.
In other words, you may be an expert, but I'm a bigger expert. And I'll just decide what it is that was meant here. But I mean, again, you have this skepticism, immense skepticism. There's a value system going on here, guys. And the value is administrative regulations stink. They are too complicated. They're too difficult. They're burdening business. If you want to go to what is this conservative organization, this think tank that always gets together, if you want to go to one of their meetings, you hear a lot of this. If you want to go to a Republican Party convention, you'd hear a lot of this. This is a political point of view, and it ignores the fact that these are complex problems, these are difficult problems, and we need regulation. In the public interest, you've got to have somebody step in and do something here.
That's right.
And the legislature can't keep up with it, but there's going to be a desire on the part of Congress or on the part of the court now to say, no, we're going to put it back on Congress. If in everything that we regard as significant, Congress is going to have to act again and again and again and again.
And I take it they don't define major questions.
No. They're just
Anything that we think is a major question.
It's just something that will be defined by case law, you know, so it'll all be separate, just depending upon what they think in a particular case. Now, the Sackett case, and thanks for reminding me of that, I almost missed it. This is water, this is clean water. The Clean Water Act prohibits discharging pollutants into the waters of the United States. Okay, the Sacketts buy property near Priest Lake, Idaho. Kind of an auspicious title here for the being in a lawsuit where you're discharging dirt. And they begin backfilling their lot. They intended to build a hole on the lot, and so they start backfilling it with dirt to prepare for building. The EPA came in and ordered them to restore the site. In other words, put it back where it was originally, and threatened $40,000 a day in penalties until it got restored. EPA determined that the wetlands on the lot were waters of the United States. Because they were near a ditch that fed into a creek, that fed into the lake, a navigable interstate lake. Wasn't there a little kid's rhyme that, you know, something that leads to this, it leads to this, it leads to this, it leads to this, it leads to this. And then this looks a bit like that, fed into a creek, okay. Now, under the Clean Water Act, the agency must establish first that the adjacent body of water constitutes the waters of the United States. And they define that as a relatively permanent body of water connected to traditional interstate navigable waters. And second, that the wetland has a continuous surface connection with that water, making it difficult to determine where the water ends and the wetland begins.
Why did that even get to the Supreme Court? That seems like Sackett should win that hands down.
Well, you know, and that's interesting, because you see, I see something like that, and I say to myself, aha, I know what's going on here. This is what we call cherry picking in the legal business. You sit back and you say, we want to get the court to start taking positions that narrow the exercise of the EPA's authority. Let's look for the best cases we can get, the ones that will, you know, just bring some dissatisfaction and shock to the ordinary person who will put themselves in the position of the person that was trying to do something here and got slapped, you know, by the EPA. So you pick them up, you pick and choose. Now, that doesn't mean to suggest that this person doesn't deserve to win this case. They may well deserve to win this case. They did. So here, how should the case be decided? I asked that question. I mean, you know, as Lawson said, it may well be a case where maybe these people ought to win, because it doesn't look like, and we don't have a lot of facts about what they were, the wetlands here. You know, there was something that got wet, but it doesn't appear to be connected to anything else that amounts to a system of water that could be defined as waters of the United States. So this was a 5-4 decision. The Sackett's lost. Well, how will this decision affect water pollution regulation affecting wetlands? You're in a very murky area now with respect to wetlands. You know, I remember, you know, when I was in school, we never used the term wetlands. The term wetlands is a relatively recent term. We called them swamps. In some cases, marshes, you know, that kind of stuff. And that was a kind of a pejorative term, you know, a term that this is not something good. There's not something terribly worthy of protection. Well, then when the environmental movement started, they kind of had to come up with their own vocabulary, and this vocabulary didn't get adopted. The vocabulary isn't going to make any difference anymore in terms of the way the court's dealing with this. So anyway, that's another case that they just decided that's going to go in the development of this home.
I worked quite a deal in wetland regulations.
Oh,
And,
Are they the same family?
yes, there have been decisions, Congress actually gave 4 different agencies authorities in wetlands: U.S. Army Corps of Engineers, the EPA, the U.S. Fish and Wildlife Service, and the Natural Resources Conservation Service. They all have authorities, but they have to agree on a definition. And this definition has been worked out between the agencies with all of their various expertise. But what was recognized over time is that when wetlands are converted or depleted, then groundwater is diverted or depleted. And then the water in the rivers, look at the Colorado River, is directly affected by the number of wetlands that have been converted and are no longer providing wetland values to that area. So somewhere back in the late eighties, the Congress decided that, and this sounds funny, but they decided that wetlands are a part of the navigable waters of the United States. And because the ducks that land in this wetland are engaging in interstate commerce, when they fly over state lines to poop in the next state. And that ducks, because of hunters, have an economic value. Okay, it's kind of convoluted. But the fact that there are connections, scientifically proven connections between navigable waters and wetlands. And anybody who doesn't believe that, look at New Orleans.
And what you do with those waters has an impact. There is an impact
Exactly.
on those water systems, even though they might not be directly connected.
Yeah.
And now the Supreme Court says, no, they gotta be directly connected. They gotta be directly connected. Well, you know, then, if it affects the overall cleanliness of water, because it requires us to draw more water out or requires us to do various things, why should that be the subject of regulation, particularly when they're trying to get 4 agencies to cooperate and get together and they succeed? That's the amazing thing, is they did that. But anyway, but again, you're dealing with a group of people. This is a value choice. This is not even law. It's a value choice. They don't like regulation. They don't like to have the government, because their constituency has told them, we don't want rules. Those rules are terrible. We would rather duke it out in litigation, you know, over what these things mean, than to have some agency be able to make rules. And this is the interesting thing. If you want to have law be efficient, you don't want to make a set of rules in a complicated area by just having lawsuits. And then you go lawsuit after lawsuit after lawsuit, and then maybe eventually we can figure out, like that car, you know, with the 20 different kinds of things, then we can figure out what the car ought to look like after 20 lawsuits.
Either that or we'll have a good drought.
Or we'll have a good drought, and maybe then somebody will scratch their head.
Yeah. Oh, what have we done?
And the classic phrase is always, classic question is always, how did we get here?
Climate change.
How did we get here? Well, you know, I mean,
New Orleans, that.
and there are all kinds of ways that we do this. Now, okay, let me get quickly into abortion, the last 10 minutes here.
I think we need more than 10 minutes.
I think we will. We will continue next time, but let me make some progress anyway. This is Dobbs. You all know what this is. The US Constitution does not contain a right to an abortion. That's the holding of Dobbs. There's nothing in the US Constitution that says to the US Supreme Court anything about abortion. And so they're going to overrule it because it's wrong. It's not based on a provision or even group of provisions of the US Constitution. So they overruled Roe versus Wade in 2 prior cases where they had adhered to Roe and said Roe was correctly decided in a 7-2 decision announced January 22nd, 1973. That's Roe. That's nearly 50 years ago. And now, 1 year after Dobbs, we're now 1 year. The 1 year anniversary is today. 62% of those polled in recent weeks believe abortion should be legal in the United States. That's a substantial majority. Yeah.
Well, okay, so did the US Constitution say anything about not having a right to an abortion? The Constitution didn't say anything one way or the other.
That doesn't speak to it, but.
So if it doesn't speak to it, how can the originalists go one way versus the other?
Well, what the originalist is saying here is the plaintiff that is attacking state statutes that put limits on abortion as unconstitutional. That was where Roe was decided. Roe was decided based on a determination written by Justice Blackmun at that time, that a number of provisions of the Constitution, if you somehow added them all together, equaled a right to have an abortion. And this court is saying, no, that's wrong. It was poorly reasoned. a right to an abortion doesn't come from these provisions. And we're talking about, due process, and we're talking about,
Life, liberty, and
well, and life, liberty, that's in the Declaration, not in the Constitution. Constitution doesn't believe in life or liberty. But I mean, so that was the determination. States, they say, as a result of this, states can still authorize or decline to prohibit abortion through legislative action or inaction, or state constitutional provisions like a right to privacy. So states, in other words, can protect them. They're arrogating all the power to states here. They're saying it's up to the state to determine whether you get an abortion or not. And when previously they said, no, there's a US constitutional right. So every woman in the country has this US constitutional right. They walk from state to state, travel from state to state. They walk around with a right. And so that right needs to be enforced everywhere.
So a human right was argued as being constitutional and it's cited for
Yeah.
the three Supreme Court now
Yeah.
saying it isn't constitutional, therefore we're leaving it to.
We go back to the.
Even though 62% of the people think it's a right,
62%,
it's not a
so
constitutional.
this is a profoundly undemocratic institution we
Right.
call the United States Supreme Court.
Really bad.
They don't care what those 62% think. They don't care anything about that. And what they do care is their view of the original intent, and they say, look, we looked at the original intent. We looked at the history of these provisions when they were enacted, and we don't find the word abortion in any of them. And so it doesn't exist. And so that's their reasoning. That's what they're saying. Now, where are we on this? First of all, we have 14 states that ban abortion outright throughout pregnancy. And by the way, Roe versus Wade, what is the holding in Roe versus Wade as to when a state can control or regulate abortion?
So that's 6 weeks?
No.
This is when you state, right?
The first 2 trimesters are within the constitutional right, and there cannot be regulation of an abortion during the first 2 trimesters. So first trimesters is what, 24 weeks? Something like that. Only the last trimester can be regulated by the states, according to Roe versus Wade. But now Roe versus Wade has just been folded up and dumped in the garbage can. So we don't have that anymore. It's back to the states to determine how they want to regulate, whether they want to regulate in the first trimester, second, third, all of them, whatever, it's up to them. And so we've got 14 that ban throughout pregnancy with these exceptions. And here, look at these states: Alabama, Arkansas, Idaho, Kentucky, Louisiana, Mississippi. Most of this stuff is just rape or incest or some kind of risk of, sometimes it's life, sometimes it's health or safety, but again, it's a mess. They're all over the place. These 14 are all over the place, and these are the hardcores. Missouri, same thing. Oklahoma, South Dakota, Tennessee, Texas, West Virginia, Wisconsin, that's my state. Interesting thing there, Wisconsin had an 1849 law, which of course was displaced by Roe versus Wade, which said no exceptions, no abortions. We don't allow abortions except to save the mother's life. And that's in litigation now in Wisconsin. They just had an election that turned chiefly on that issue. And the new justice on the Wisconsin Supreme Court is somebody that ran on a pro-abortion ticket, to get her job as a judge. But there she is. And so that's gonna come up here. Now here, another 3 states ban after 6 to 15 weeks. 2 other states have adopted a ban, but it's not yet in effect. One of the problems here is that there were all kinds of ways that, Roe took some states by surprise. There were other states that had passed a law already that would go into effect when Roe versus Wade. I mean, so we got a lot of messes here. And those are all being challenged because of the way they were worded and the way they were done. 6 states a ban of some sort has been stayed by court order. And that doesn't mean that these states won't ultimately ban abortion. Or I should say, I shouldn't say ban abortion, I should say that they won't be able to institute in those states criminal laws that ban abortion. Abortion access specifically protected in 21 states. And you see California's in there. We have protected it both by legislation, and we have a constitutional right to privacy, which has been determined to apply to abortion as well as an incident of the right to privacy. So we're well protected and well layered here, as is true of some of these other states. What did I read about? New York is involved in some interesting litigation. There's 6 states have had no change since. So that these states have not done anything since Dobbs, and so that it remains pending in Alaska, Iowa, Kansas, New Hampshire, Oregon, and Virginia. So, okay, here are the selected outstanding issues, and we'll talk about these in more detail next time, but I'm just going to list them for you. The first issue is a contraception ban. Roe versus Wade comes in a line of cases from a case called Griswold versus Connecticut, where a student at Yale challenged their ability. They weren't allowed to purchase contraceptives. And the Supreme Court struck that down as a violation of the right to privacy. Well, Clarence Thomas, in his concurring opinion in the Dobbs case, said we need to revisit that. That's now, up for grabs because privacy's gone, and so this ought to be gone. So there's no contraception anymore. Or contraception can be banned and can be regulated in those states. So that's a pending issue. That's up for grabs.
And that's for both men and women, right?
Oh, sure.
Oh, okay.
Sure. But not according to Thomas, he won't vote for that, but maybe he'll get some votes.
The guys.
The second thing is abortion pills. Pills account for 50% of abortions right now. Now, guess what's going to happen there, given this change in the law?
Interstate commerce.
Going to go out. You're going to see people wanting to do it this way because here they're in a state that has a whole bunch of restrictions. And my gosh, all I got to do is go down to the drugstore and buy some of this stuff and take it. And they'll join the 50% that are already doing it that way. And that'll go up to 60 and 70 and
I mean, how much will the pills cost?
I don't know. Anybody ever buy any of these things?
No.
Aren't they banning the pills in a lot of these states?
Well, this is a question.
Yeah.
Now, I took this stuff off of NPR, and I haven't read any of the litigation on this. Mephisto is the name of the pill here, was approved for use by the FDA 20 years ago. It's been used by more than 5 million women. And today, more than half the women who end a pregnancy rely on the drug. Yeah. So this is, and the FDA has loosened restrictions on the drug's use, extending from 7 to 10 weeks. So the FDA, of course, is in the business of determining whether something is safe and effective. That's their language. That's what they do. And if it is, they expand the use of it, and they've been doing that consistently. So there it is. Now, and there is there's a second pill. Misoprostol is also out there and is somewhat less effective. But those 2 drugs are out there. So, okay. So this is interesting, and this is going to be, there will be challenges to this because states will try to ban the use of these drugs, or the sale of these drugs, the distribution of these drugs, the possession of these drugs. They'll have all of those laws in effect, and they'll all be challenged. So I didn't have a chance, before I came into that, I was gonna call our daughter, our middle daughter, works, in the legal department. She's an associate general counsel at the FDA. And I was gonna ask her, has the SDA encountered this problem before now? Because undoubtedly it has. You know, I would think, for example, and Beth gave me this example, she was talking about this, and she said, what about that? What about all of these vaccinations that we have, you know, and all of the objections? People don't want to be vaccinated and they don't want, but, I mean, can't these states just come in and pass statutes and say, we're not doing any vaccination here? And directly interfere with FDA approvals of those things and that kind of thing? Well, the answer to that is clearly gonna be no. You know, that's been reviewed and people didn't even bother to bring the lawsuits. And so, you know, I doubt very much that they're gonna get away with banning the sale, distribution, possession of these medications. And once that happens, you will have a major hole in this whole Roe versus Wade overruling. Because there'll be a way to take the pill and it's gone. And so that's it. So anyway, we're over time at this point. So I will stop here because we're going to talk a little bit more in detail about what's the likely impact of this. Some states are trying to legislate extraterritorially, which is just unbelievable to me. You say, I'm going to regulate the conduct of somebody doing something in another state. Oh my gosh, you know, but I'll tell you something, lawyers love it. I got a stack of books like this at home in one pile that deals with the subject of conflict of laws, which includes extraterritorial applications of laws. And so it's a subject of great studying, and that's it. But we'll pick up here next time and talk in some detail about the impact of this.
Plus everything else is gonna come out in the next week.
With the Supreme Court that we have, how do you feel, how successful do you feel these